Thank you again all so much for joining us. We are really, really excited to have you with us this evening. Um, so glad to have you here with us, fans of civil discourse. My name is Emily Voss. I'm the Senior Manager of National Programs and Professional Development at the Center for Civic Education. Welcome to the inaugural program of our brand new series, 60-Minute Civics. For those of you who have followed the Center for some time, you might be familiar with our podcast, 60-Second Civics, which recently celebrated the milestone of 5,000 episodes. And tonight marks the beginning of a brand new chapter as we delve deeper into the heart of civic issues, both historic and contemporary. 60-Minute Civics will be a platform where we can explore, analyze, and discuss the intricacies of our civic landscape in depth. So for our very first installment this evening, we have chosen to address a pressing and current civics issue, the recent decision by the Supreme Court in the case Trump versus Anderson, also known as the Colorado ballot case. And this evening, we are honored to facilitate a moderated discussion that will unravel some of the complexities surrounding this significant legal development. We definitely encourage your active participation. Your questions, your thoughts, your perspectives are crucial to enriching this conversation. And we invite you to utilize the chat feature to pose questions or seek any clarification. So without further ado, let me hand over the reins to our moderator for this evening, Chris Cavanaugh. Chris, a Bismarck High School social studies teacher and previous winner of the American Civics Education Teacher Award, brings a wealth of knowledge and expertise to guide us through tonight's discussion. We are excited to embark on this journey with you all, and welcome to 60-Minute Civics. Chris.
Thank you very much, Emily. I appreciate this. I really appreciate the chance to do this. I've been pretty geeked out about this all week. Welcome to everybody that's logged in from around the nation. And welcome to Donna Phillips, my fellow inaugural winner of ACETA, the ACETA Award. So I'm really, and contemporary does not begin to, the word contemporary does not begin to describe, obviously, our topic for this evening. But I'm so excited because I get to hang out with two people that I've learned so much from. So I get to introduce our scholars this evening. First up is Sue Leeson, Justice Leeson. Justice Leeson served on the Oregon Supreme Court, the Oregon Court of Appeals, clerked in the Ninth Circuit Court of Appeals, was a judicial fellow with the United States Supreme Court, and holds a PhD in government. Welcome, Justice Leeson. Also, we have Professor Hank Chambers. Professor Chambers is the professor of law professor of law and Austin E. Owen Research Scholar at the University of Richmond, Virginia. He teaches and writes in the areas of voting rights, employment discrimination, constitutional law, criminal law, and law and religion. His recent essay, Douglas, Lincoln, and Douglas Before Dred Scott, A Few Thoughts on Freedom, Equality, and Affirmative Action, considers how past visions of equality and inequality continue to arise in today's affirmative action discussions. And he is also the editor of the pocket pamphlet, American Legacy, the United States Constitution and Other Essential Documents of American Democracy, which I just happen to have a copy right here. Always keep it on the desk. And I've got to add a personal note. I have studied at the feet of these two scholars over the years, and I have learned so much from both of them. So one of the reasons I'm also very geeked out about tonight. So why are we here? We're here for Trump versus Anderson, a Supreme Court case that was just heard in an expedited fashion, and whether or not the state of Colorado can keep a presidential candidate or someone that they believe engaged in insurrection off of the ballot. I think we need to start, obviously, with the piece of the Constitution where the argument begins, and that is the 14th Amendment and Section 3. And I think, Mark, you are our man in terms of charge and putting up things for us. If you could put that up for us, that'd be fantastic.
Absolutely.
Thank you.
Sure. Let me just get to the right thing here.
And for those of you that are not familiar with Section 3, this is part of the 14th Amendment, ratified in 1868, known as one of the Civil War Amendments or Reconstruction Amendments. Obviously, we have the 13th Amendment that abolished slavery, ratified in 1865. The 14th Amendment, which does a lot of things, as many of you are familiar with, ratified in 1868. And then the 15th Amendment that you could not deny a person the right to vote based on race, color, or previous condition of servitude in 1870. All of these amendments are important, obviously, and all of them are the first time that I think in the Constitution in amendments that will have something called the enforcement clauses. And I think that enforcement clause, Section 5, will come into play in a little bit. So I'm going to read this for you, and I know this kind of, you're all literate or you wouldn't be here, but I'm going to go ahead and read it anyway. Death by PowerPoint, sorry. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such a disability. Whew. That is a long list of things, but it is there because obviously coming out of the Civil War, they were worried about the people that engaged in rebellion entering into government, whether that be at the state level or the national level. And this leads us to what happens in Colorado. And Colorado basically tells us that, well, wait a minute, we think that former President Trump engaged in insurrection, and we believe we have the authority then to actually remove him from the ballot. And I think if the, Mark, if you can go ahead and take that off of the screen, that would be great. Thank you very much. Because the question was, this is the question before the Colorado State Supreme Court, which eventually gets there, that his name was not to appear on the primary ballot or write-in votes should not be counted. He is constitutionally ineligible to serve as president again. And their reasoning was such. The Colorado election code permitted 4 Republican and 2 unaffiliated voters to challenge Trump's presence on the ballot based on Section 3 of the 14th Amendment. Section 3 is self-executing, according to the Colorado Supreme Court. So Congress does not need to pass implementing legislation in order for disqualification under Section 3 to attach. And the political question doctrine does not preclude judicial review of former President Trump's eligibility. The district court did not abuse its discretion when it admitted into evidence a portion of congressional report of the events of January 6th. And the Colorado trial court did not err in concluding that those events constituted an insurrection, and that former President Trump engaged in that insurrection, and former President Trump's speech to the crowd that breached the Capitol on January 6th was not protected by the First Amendment. That's a pretty much a nutshell of what comes out of the Colorado ruling, and therefore he's removed from the ballot. I'm going to stop there because you guys don't want to hear from me. We want to hear from Justice Leeson and Professor Chambers. So let's go back to the Section 3 of the 14th Amendment. And what history do you think, either of you folks, what history do you think our viewers need to pay attention to here with Section 3 specifically, or the 14th Amendment in a larger context?
I'll let Hank start.
Oh, go for it, Sue.
No, I want to start, if you don't mind, Chris, with Article 6, because
yes,
when it says that this Constitution, the laws of the United States made pursuant to it, shall be the supreme law of the land, we stop there, but that's a semicolon, and the judges in every state shall be bound thereby. So that is the invitation to the Colorado state courts to weigh into the question of what does Section 3 say, and how do we determine whether an insurrection has occurred, whether a person has engaged in it, whether it's self-executing, et cetera, et cetera. So I think the trial court and the appellate courts went into this with a clear understanding that they had a duty under the United States Constitution to deal with Section 3 of the 14th Amendment.
Outstanding. That's a great insight. I really had not thought about that part, but that's very good. Thank you. Hank, would you like to add to that?
Let me personalize this just a little bit, because if you don't love Sue Leeson and can't give her a hard time, then what's the point? And that's this: if you think about Section 3, Sue took an oath pursuant to Article 6 when she served on the Oregon Supreme Court, where she promised to support the Constitution. What Section 3 says is, after taking that oath, if you then do something that is so inconsistent with that oath, namely engage in insurrection, rebellion, etc., then you can't serve in another role that requires that you take the oath again. As I say to folks, fool me once, shame on you. Fool me twice, shame on me. What Section 3 says is, we're not going to give you a second chance to mess up the oath again. So let's be clear. It doesn't say all insurrectionists can't serve. That's not what it says.
Right.
It says if you took a prior oath and you went contrary to it, and now you're trying to get back in, no. So that's a big piece of what's out there, and recognize that piece says if the person involved was a state officer and wants to be a state officer again, no, you can't do it. The federal Constitution says no. So that became a big part of the court's decision. But let me stop there for just a moment, because I can talk about this all day. Sorry about that.
No, that's great. But also, I think it's important for people to make sure that they understand that the framers of the 14th Amendment also put in a way in Section 3 for people to say, hey, you know what? You did fool us once, and you're going to have to really get over a really high bar to get back in. So we're going to have to, we're going to 2/3 of us agree that we're going to let you back in, right? So the idea is that, we have an avenue for possibly letting you in, but that bar is really high. Does that seem what you guys would agree with?
Mm-hmm. Mm-hmm.
Yeah, that's right. The idea that Congress can look up and say, look, we understand that someone may well have engaged in insurrection. We realize they may have engaged in rebellion. They may have engaged in a civil war, but there may be a time after which our notion is it's just more important to move on. And indeed, it may well be the case, depending on the reason why they engage in certain behavior, that one may very well say, we get it, and we don't necessarily believe that you are unable to serve moving forward, even though you may have violated your oath before. That is, we may understand now that you're right with us because we've decided that you either have repented or that we just believe that your reasons for rebellion were sufficiently reasonable that we think you can serve consistent with an oath moving forward.
Okay, and so the Colorado Supreme Court says that means we have a duty to make a finding, and the trial court did that. They held 5-7 hours on what constitutes an insurrection and did the former president engage in it and so on. And so it concludes that he is excluded from the 2024 presidential ballot. Now, here's one of the things I find interesting about the opinion. The appellant always asks the court to do something in a yes or no way. And so what former President Trump asked is, did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? Yes or no? And the court answers unanimously yes, and that's all at least CBS covered on the morning of the opinion came down. Notice a couple of things about the framing of the question. They bought the appellant's framing 100%, including calling him President Trump. Notice on the immunity question, which is now also before the Supreme Court, they rejected the appellant's framing of the question and have reframed the question they're willing to answer in a way that really has people scratching their heads. But they took former President Trump's question verbatim and came up with an answer to that, which was the Colorado Supreme Court did err. And that's what we're, according to Justice Barrett, all supposed to take home and not worry about and not become too engaged in contentious disputes over what else the court did that people are now starting to wake up to.
Yes, and I saw that was someone in the chat that asked what the question was, and Justice Leeson had just read it. It's really straightforward, and this is why I love the website OYA for my students, because they can go right to that, and every argument hinges on a constitutional question or questions, and this was simple: did the Colorado Supreme Court err in ordering President Trump not former President Trump, excluded from the 2024 presidential primary ballot. That's it. I mean, and it's either a thumbs up or a thumbs down. It's pretty simple.
Right. Yeah. Now, let me add one additional piece of the puzzle that's a little bit messy. As Sue noted, the Colorado trial court had a trial. That's the bread and butter of what state trial courts do. An issue arises before them and they have a trial. And during that trial, they make a determination.
Well.
Exactly. And generally speaking, as long as there isn't anything untoward about the trial, then the state appellate courts, state Supreme Court say, okay. And then the U.S. Supreme Court can say, okay. And indeed, when you think about death penalty cases, that's how it works. And indeed, boy, would it be interesting to go back and take a look at the kind of deference that is paid to trial courts when you're talking about death penalty as opposed to trial courts when you're talking about other things. But the reason why I note that is because what the trial court did, however, was say, yes, President Trump engaged in insurrection, but they determined that the presidency of the United States is not an office and that the president wasn't an officer of the United States, which I will say is, from a legal perspective, kind of nuts. I have said in the past that it was straight bonkers, but I recognize that this is a more august group. So I probably ought to say nuts instead. And that was part of the reason why the Colorado Supreme Court's decision then said, okay, we accept the fact finding of the trial court. We think they were right on that, but we think they were wrong on the law. And because they took the position that the president of the United States is covered, it's an office and the president is an officer, they said, hey, he's got to come off of our ballot. And there's a legitimate reason for that. That is, why would you want your people in your state voting for somebody who can't serve?
Bingo.
So that was part of Colorado's argument, is we don't want our people voting for somebody who we know can't serve and who isn't qualified to serve. So why would we let them do that by putting them on the ballot? That's a part of what was going on as background.
Yeah. So I think for people tuning in, I think what Professor Chambers is just laying out for us is a fantastic explanation that due process was given in the fact-finding court.
I'm going to disagree with you there, Chris.
You don't think that President?
Yeah, they never addressed the due process question. It was raised in a number of the briefs.
No, my point, and this was that he was given due process at the state level in the fact-finding court. You know, he had a chance to present evidence. He had a chance to, his attorneys had a chance to present evidence. They had a chance to call up witnesses. So your argument is at the state level, the fact-finding court?
I think we have to be careful with how we use the term due process. Remember, people aren't guaranteed due process. The provision says no one shall be deprived of life, liberty, or property without due process. Okay. Now, there are some Sixth Amendment questions that are different from those due process questions. And if the court had gotten deeper into the merits, the due process question, I think, would have been interesting, because I don't think any of us has a life, liberty, or property interest in running for office.
Roger that,
for
sure.
You're not taking anything away from, but I point that out only because I worry people get distracted by, well, that wasn't really a fully vetted trial at the Colorado trial court level and so on.
But I think also too, for our folks tuning in, that at that level, that court is the fact-finding court, and the Supreme Court is not necessarily a fact-finding court, as I understand that.
Appellate courts do not find facts unless the court is exercising its original jurisdiction, which is very rare.
And Hank, I think actually I was listening to Professor Akil Amar respond to the argument about officer and office, and his response to the person raising that question was, "Are you on drugs?" I think you handled that pretty well compared to Professor Amar, who I also hold in high regard. Okay, so we've got this. The question is before the Supreme Court. Did the Colorado Supreme Court err? And we have a per curiam opinion And could you guys just briefly explain per curiam to our viewers and why that's there, what that means?
I can answer from the perspective of my court and what I saw in the Ninth Circuit and at the Supreme Court as well. When the court wants to speak unquestionably with one voice, this is your institution speaking. Believe us, because we are speaking with one voice. They issue what's called the PC, or the per curiam. Now, when the court did the other controversial case in Bush versus Gore, there were dissents and concurrences. So the appearance of the institution speaking with one voice collapsed, as it does in this case because of the concurrences. So that leads us to speculate what else might be behind this being a PC. Well, you don't have to list who all is participating, including a justice whose wife has been involved in a number of the problems leading to this political chaos, who participated without recusal. You don't have to list at least 2 of the people who the appellant appointed to the court, and so on. And so there may have been some of those strategic reasons. Now, I think most people are concluding that the chief authored the per curiam because of the way Justice Sotomayor quotes his own wording back at him and saying, "What in the world do you think you're doing?" But that's all speculation. We don't know.
Yeah, and it's a great point. In that sometimes people look at per curiam and they say, "Oh, well, it must have been 9-0," and the answer is no, it doesn't. It's indeed the more cynical folks, the very cynical folks would say, "Yeah, nobody had the guts to put their name to it," and that's a slightly more cynical way of looking at it. But that's one way that some folks have argued that that's part of what's going on, because certainly we see in this case concurrences that make you scratch your head and say, boy, that looks, yeah, it's a concurrence, but wow, is there a real disagreement about what's going on? And like I say, for example, is the court talks about federal office holders,
yeah,
and that the state can't disqualify federal office holders. Now, of course, those federal office holders are disqualified by Section 3, so it's not really the state doing so, but
yeah,
they say you can't disqualify federal office holders, and seem to include U.S. senators, congresspeople, etc. Well, it's not at all clear from the concurrence that they agree.
no,
Their notion was, all we're asking about is the president, and all we're determining is the president, and they don't mention anything about whether a state can disqualify a U.S. senator. And one of the reasons why that's particularly important to me is if we take federalism seriously, then we would say a U.S. senator is the state's representative to the federal government, not a federal office holder. That switch has been quite wild for me, to have an opinion that talks about federalism as much as it does, but to then completely misunderstand what federalism is troubling. It's not shocking, because they essentially wrote this on the back of a napkin and said, hey, let's go ahead and put it forward, because they did it fast. But it is troubling to me and raises some really interesting questions about what they're going to do with federalism moving forward. That is, at least if they take it seriously in other cases moving forward.
That was Professor Hank Chambers, everybody. So if you want to direct your comments about the back of the napkin to him, that's great. And also the point about the senator, because obviously Section 3 ratified in 1868, we don't have the 17th Amendment yet. So the idea that states should be able to say, okay, we're not putting this senator, I don't know, say Alexander Stephens, former vice president of the Confederacy, we're not going to put him on the ballot, which of course we know he is not seated along with others. Okay, so we have this opinion.
And I'm going to suggest that that amendment is irrelevant. How the senator was selected has changed. Yes. That the senator is from the state hasn't changed, and makes me wonder if the history not only of the Civil War, but the history of the Constitutional Convention and why elections for so-called national officials occur in the states is something that the court is paying careful attention to, because it remains critically important.
Yes. Well, let's get into. I mean, we've talked about the opinion a little bit. We've kind of gone back and forth here with some of the things in the opinion already. And there was that very simple question, right? Did Colorado err? Did they make a mistake by excluding him from the ballot? And the per curiam opinion, which I think people are going to argue that probably Chief Justice Roberts did author, and it sounds like is one of his opinions. From what little I know. But so I'm going to kind of put you guys on the spot. There are multiple issues here, but what do you think is your biggest issue with the opinion?
I want to first just make sure everybody understands how the court sorted through the opinion, because it's a very short opinion.
Yes.
Part 1 goes into the history and how we got here. Everybody agrees on the history and how we got here. Part B then says we can't have this patchwork of state enforcement of the 14th Amendment. We're going to have chaos. Everybody agrees with that. So the challenge is what went on in their analysis of the question that wasn't before them. And that's where the opinion is, I think, getting so much attack, is the court reached out to decide questions that were not before them. And that's what Justice Sotomayor, writing for herself and Kagan and Jackson, there's no federal action here. There is a state interpreting the 14th Amendment, Section 3. And the court says, well, gee, you can't do that because things might be different all over the place. Why not just say that and get off stage? And so a couple of sentences in the concurring opinion that I find fascinating, and then I want us to look at what are some potential fallout from this opinion going forward. Justice Sotomayor writes, the court is effectively trying to insulate itself and Donald Trump from future controversy over Section 3. Now that, when we stop and think about it, is a stunning accusation and perhaps a stunning truth, in which case this decision may be looked at in the future of one of the court's big self-inflicted wounds. Another reason some people think it was written as a per curiam, because of that, in at least 3 judges' view, the insulating political implications. And then we protest the majority's effort to use this case to define the limits of federal enforcement of Section 3. What did the court say about congressional enforcement? Does it have to pass a law? Can Congress convene and just say no? There's just so much created uncertainty that the concurrences have pointed out. That's led Judge Ludig to say this is stunning in its overreach and shocking and unprecedented.
I do
that's pretty amazing coming from Ludig. So,
well, he's been very vocal as over the last few months, for sure, and a very interesting
yes.
on social media, and very accomplished jurist. I do like the opening sentence of Justice Sotomayor and Kagan and Jackson's concurrence, because they quote Justice Roberts from Dobbs in the very first sentence, and it says, "If it is not necessary to decide more to dispose of a case, then it is necessary not to decide more." Yep. So there you go. Hank, what's your takeaway here?
Sure. Look, hey, Mark, can you throw up Section 3 one more time? Because what I want folks to recognize in this opinion, I mean, it is the case that the opinion's takeaway is that it would have been chaos to let a single state make a decision that would have an effect on the national election. Now, I will say that I am old enough to remember Bush versus Gore. And as a consequence, the notion that chaos is an issue is just nonsense. It's absolute nonsense. Now, I don't care which way folks came out on Bush versus Gore, but our structure allows for single states to have an effect on the on the election because of the way we do the electoral college. So every time someone says that the election for the president is a national election, I know it's very difficult to recognize it, but I blanch at that.
No, it's not.
It's very difficult to see me blanch for obvious skin tone reasons. But I blanch at that because we know that it's not a national election.
No.
But the reason why I have Section 3 up here is if you were to look at Section 3 and you were to add the last sentence of the first part of the per curiam, and the last sentence is of the per curiam of the first part of the per curiam opinion of the first couple of paragraphs says, because the Constitution makes Congress rather than the states responsible for enforcing Section 3 against federal office holders and candidates, we reverse. I defy you to look at Section 3 and find anything in Section 3 that actually says that or comes even close. And that's the problem that I have with the opinion is if I were to give that if I were to give Section 3 to my students and give that language from the per curiam opinion to my students and say, okay, find it in Section 3, their response would have to be, it's not there. There's no distinction in terms of state officers versus federal office holders. There's no distinction necessarily between the president and other officials. We can have a discussion about that, but there's nothing specific that talks about that. So my biggest problem is if you simplify the opinion to what they want to simplify it to, and you then apply it to Section 3, what you realize is that the court just makes stuff up. Now, that doesn't mean that they are wrong about saying we think that that Section 3 should be applied this way. But to say that it does apply this way, and that's the only way for it to apply is just nuts. And it suggests a judicial supremacy that is very troubling. Now, I recognize they have to make determinations, and they will make determinations, but very, very troubling. That's part of what is bothersome to me. And I will say, with respect to the concurrence is frankly no better in terms of acting as though Section 3 applies to the president, or I should say that Section 3 limits states vis-a-vis the president.
Yeah.
And we're going to leave all the other issues to the side. Because again, the chaos question is there because of how we run the Electoral College, because of how the Constitution runs the Electoral College. It's not there because individual states engage in bad behavior.
Well, and let me follow up with that then, because isn't there an inconsistency from state to state how electors are determined? But that's provision is provided for in Article 1 of the Constitution, giving states so much power to run elections.
That is absolutely right. And indeed, if we were to go back to Bush versus Gore, what we find out, because the court said so, is the people only choose electors because the states allow them to. So it's a very odd situation. It's a very odd situation for us in this circumstance. And I'll give you one more hidden piece in the first clause of Section 3. I will note that Section 3 has far more commas than it should. There probably ought to be a couple semicolons or periods in there, but that's okay. And that's this. It says, no person shall be a senator or representative in Congress or elector of president and vice president. Here's a question to ask you.
Yes.
If the court's position is that a senator or a representative is a federal office holder because it relates to the federal government, then doesn't that mean an elector for president and vice president also must be a federal officer? Because their only reason for existence is to choose the president. Yeah. And you can't say, oh, but they're chosen by the people, because that's true of senators and representatives. So there's a real question here. Would we honestly believe that the elector for president and vice president are federal officers? Do we really believe that this court would take that position? Do we really believe that this court would limit states in how they could choose that individual? Because that's completely inconsistent with Bush versus Gore.
Well, and we have a number of insurrectionists who have been convicted who well may seek in their states to serve as electors.
Right.
What would this opinion say about that?
It's a fine question, and here's one of the ironies: is if they're just insurrectionists, If they didn't take a prior oath, then Section 3
Doesn't
actually
even
says,
apply to
let them
them.
serve. Right.
Yeah.
So it's a real interesting question in terms of what the court did. And here's why I think that I agree that Chief Justice Roberts probably wrote the first part of the opinion. I wonder whether he wrote the second part. And the reason why is because the second part of the opinion is the part of the opinion that people will criticize as being very problematic. And he does not want to be criticized, and understandably, because this court's going to be the Roberts court. It's not going to be anybody else's court. It's the Roberts court. So if there's criticism, there will be a stain on his name. So I can see him writing the first half. In fact, I could see him saying, can we please just write the first half and have a 9-0 decision and move on? The second half, I see Justice Thomas, Justice Alito, and maybe some other folks involved in that, because it's the second piece that has folks really scratching their heads. And it's the second.
So why do you think the chief joined? He could have one person would have flipped this the other way in terms of getting that Section 2 just out of there.
Yeah, it is. I think he wanted as close to a 9-0 decision as possible.
He could have had it.
I agree, and I suspect that he would. It's hard for me to imagine that he didn't want that. That he didn't want to say, "Can we please just write the first piece and be done with it?" And it wouldn't surprise me if for some reason somebody said, "No, I want to have more." So,
well, I think, and reading the tea leaves here, the idea that things have been written, that if you click on the link of the metadata, that it shows that originally Justice Sotomayor, or the concurrence of Jackson, Kagan, and Sotomayor, actually was originally a dissent written by Sotomayor. And reading some other folks, I'm wondering here, listening to what you're talking about, Part A and Part B, Hank, is I wonder if Kagan and Jackson were going to just say, okay, we're going to go with Part A, we're going to leave it at that. But then all of a sudden Part B comes along, and they're going to say, no, we're going to jump on to what was maybe originally a dissent by Sotomayor, so we can say, no, we're not buying into this part of that, as opposed to saying, okay, Part A, states can't do this, we're done. Colorado, you erred. Former President Trump gets to be on the ballot. We all get to worry about the immunity case. My question, and I don't understand this, honestly. So what the court is saying in its opinion is, okay, states, you can keep people off state ballots. You have that power, but you don't have the power to keep people off federal offices. And again, I've read this once or twice, and I don't see that language anywhere here or in Section 5, the enforcement clause, because the enforcement clause, which is pretty straightforward, we don't need to put that up. Congress have the appropriate Congress has a power to enforce this amendment through appropriate legislation, very much like the necessary and proper clause in the body of the Constitution. Similar to that, for any true historians that are watching. So I don't understand, where does it say that? Where does it say states?
The court may have a chance to address that if it allows review in the Coy-Griffin case. The New Mexico commissioner who was taken out of office and is not allowed to run again. Again, the New Mexico court construing Section 3 of the 14th Amendment. Now, Griffin has that on appeal. The court may well turn it down because there could have been an independent state reason for taking him off the ballot. But in fact, the New Mexico courts addressed the Section 3 argument involving a state official.
Right. And so here's one of the reasons why it gets real interesting. The fact finding necessary to demonstrate that someone engaged in an insurrection is the same for a state official as for a federal official.
Well, this guy was found guilty of trespass. He was not charged with having committed an or engaged in an insurrection. And so I'm finding that intriguing as well. Based on that criminal trespass conviction, they disqualified him from office holding in New Mexico.
Right. My point is just that whatever fact finding is done by a trial court.
Right.
And and the same kind of fact finding that we would do for a trial court vis-a-vis a state office holder is the same kind of fact finding we would do for a supposed federal office holder. So if the Supreme Court says it's okay for states to bar someone from a state office, it seems to me that the same process would be just as legitimate as for a federal officer, and they've got some explaining to do if their notion is right.
And if they take Griffin's case, they're going to have to do that splaining.
Yeah.
And Sue brought up Griffin's case, which is alluded to several times. It's not a precedential case because, Chief Justice, who wrote the opinion? Help me out here.
We've got different. We're talking different Griffin's cases, Chris. There's an old case that Justice Chase on circuit said one thing and then different one. We're talking about a guy in New Mexico now, Coy Griffin, who's been convicted of trespass as part of the J6.
Yeah, I remember when he was removed from office. Absolutely. And because the state of New Mexico said, yeah, well, there it is, you did it, and so you can't hold office. Because Griffin's case from Chief Justice Chase he was writing circuit on that one, and he contradicts himself on the case with Jefferson Davis.
Absolutely.
And let me note, in Griffin's case, the old Griffin's case, a lot of folks mention that one. It's a little bit disingenuous, and here's why. In that case, the argument that was made is that a state court judge who was serving in contravention, arguably, of Section 3 should have every one of their decisions disqualified.
Yep.
And we understand why the response is, boy, I don't know if we can do that. Right. That is a fundamentally different question than what's going on here. So Chris is absolutely right. One, it was an appellate court decision and not a really Supreme Court decision, but the context was one that was quite different. The idea that essentially we would reach behind and say, even though this person was in office in the state, we're just going to view every one of their decisions as being ultra virus. That's a problem. So we understand the problem in Griffin's case, the old Griffin's case, as being so different from this one that to use it as an analogy, I think if a student used it as an analogy, we would say, ooh, I don't know you want to do that because they're just so different. But hey, if you're the Supreme Court, you can do what you want.
Well, and in true context, as I understand it, Chief Justice Chase was considering a run for the presidency. Yes. So you certainly don't want to alienate possible voters by saying, yes, this former enslaved man, Griffin's had a case, which was a habeas case, as I understand it. Yep. So I have another question for you guys, and this is an intriguing question for me, I think, and inquiring minds want to know. Let's say that former President Trump, he's granted immunity. He can run again, and whether he's charged or not, it may not dissuade some of his followers. Could Congress remove him from office then? If he's elected, could Congress use Section 5, his enforcement power, as laid out in this case? Can they remove him from office for being an insurrectionist?
I don't think the Supreme Court has answered that question, whether the only enforcement route is through legislation or if, in fact, 2/3 could disqualify him. The chance that 2/3 of Congress is going to swing Democratic makes it, in my view, pretty hypothetical.
But you would need 2/3 to say you're good to go. But now they're saying, well, now it's just a simple majority. So
disqualification. Yeah.
So I wonder, I mean, if that's, I mean, I'm gauging in a Justice Breyer hypothetical here, but is it possible?
I would say this, it's theoretically possible. However, in order for the president to serve, he would need to get past, he would need to have his votes counted and the electoral votes for him counted in his favor. And it would seem kind of odd for a Congress that said you're okay to serve to then turn around and say you're not okay to serve. And it
Not
wouldn't surprise me if
later.
the court said that that's so inconsistent that that's not the way you're allowed to do it. The court also noted that the proportionality and congruence test that was that the Bernie court talked about, they've sort of revived it, or at least mentioned it a little bit, and I'm not sure quite what they mean by that. So it's going to be a real interesting question. If Congress acts, Congress is not the states. So in theory, one might say, well, Congress ought to be able to do what it wants to do. But Congress has the same political issues that the states have, which arguably is what the court's really talking about anyway. So do I think if Congress took that position that it would occur? It's hard to say that the court would say it's okay for Congress to remove the president in a way that doesn't really feel like Section 3. Section 3 doesn't talk about removal. It talks about folks being disqualified in the first instance. And it wouldn't surprise me if the Supreme Court said, once you allow his electoral votes to be counted, you have functionally said that he is qualified for the office. And having said that, you are not allowed to say that he's disqualified for the office.
So what happens on January 6, 2025, thanks to the Electoral Count Act, that they're now tabulating and they haven't finalized the vote of the electoral votes, could members of Congress saying, so no, we're not going to count these because he's an insurrectionist?
That is a very messy question.
Yeah, that's a mess.
I'm known to throw grenades into things. So
I have another theory. Once the court realizes what a deep hole they have dug for themselves, I think they could argue that the Part 1A is just dicta, not necessary for the outcome. They put up a trial balloon, somebody popped it, and they can say, well, don't rely on anything we said in Part 1A because that's just dicta. It wasn't before us. We didn't have to decide it. Another thing they seem to have done is said if Section 5 requires congressional enforcement, doesn't that effectively make it a political question? And that they can go back and say, pardon us, we should we didn't have to say all of that, but this is really up to Congress. It's a political question. We've cleared the way for Donald Trump, but we're not going to go any farther.
Yeah, it can be messy. January 6, 2025, I think will be messy again, regardless of what occurs, because you're going to have lots of complaints. And indeed, I wouldn't be at all surprised if you see a certain number of folks on either side challenge electoral votes. And the point of the ECRA was to get away from that. So that's where there's a real irony there. The point is to get away from that. And of course, the cleanest way to do that in this circumstance would be to have a determination regarding whether someone actually engaged in insurrection or not, and just saying, well, we don't think he did, and as a consequence, he can run, as opposed to, we're not going to say. Because remember, the court said nothing about whether J6 was an insurrection or whether President Trump was involved in it or not. So that's an open question.
And even more troublesome is their reliance then on the Enforcement Act, which also does not define insurrection or engage in. It's not been invoked all that much since it was enacted. And courts have used different standards, saying if you're guilty of any crime, you've engaged in insurrection. So in some ways, trying to kick the can down the road still doesn't help us.
Well, I think of one, I think in the concurrence, they referred to an oath-breaking insurrectionist. So they laid that out there. And in terms of dicta, I always think of, obviously, Chief Justice Taney, and which makes me think of Justice Barrett's concurrence about the temperature of the nation. Well, I don't know. In 1857, it was the heat was on, so to speak. So talk about dicta having an influence there for sure.
Oh, no, I think it has a huge influence. I'm just trying to think of if they realize that they have potentially dug themselves into such a terrible deep hole, if there are some ways out that aren't an admissible, just forthright mea culpa.
Well, here's a point perhaps for round 2 of this 60, it could be at 120-minute civics. So Sue, you mentioned the Enforcement Act, and then we go to Cruikshank, which the court says, well, no, Congress, yeah, you can't use that Enforcement Act in 1870 against these guys in Louisiana that were trying to stop these African American men from voting. You don't have that power. So wait a minute. Congress passed the Enforcement Act to allow them to enforce parts of the 14th Amendment, but the court said no. So,
yeah. Well, it's a complicated statute and it's been amended a ton of times, but it still has that wording in it of engage in insurrection. Yes.
And I think I'm getting a note from our boss here that we probably should take some questions from all the folks that are here. Emily, have you had a chance to look at the chat? Because I'm suffocating listening to Sue and Hank. So.
Well, and you have managed to successfully address many of the questions throughout your conversation, so that's awesome. But I do want to raise a question about the nature of the claim that the president is not an officer of the United States. So the viewer has brought up in Buckley v. Vallejo, the Supreme Court defines the officer of the United States as someone with significant authority pursuant to the laws of the United States. And shouldn't the president fall under that? And why didn't the Supreme Court address this claim further?
Well, the easy answer for them, if they had chosen to go there, or at least the argument that was made, is if you previously took an oath to support, and there is a constitutional oath that everybody has to take to support and defend the Constitution, the presidential oath is different, and it is the only one that is in the Constitution itself. And so the argument is that the kind of oath that a president takes is different from the kind of oath that, if you will, other officers take. And so Section 3 doesn't encompass the president. It was there in an earlier draft, it was taken out, blah, 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 blah. I don't think that is a strong argument, but it is certainly one that was made in the briefing. And if you also read Article 2, he shall hold his office. Well, what is his office if he's not an officer? But the court didn't need to go there in its view.
Right, and I do think that the notion that the president is not, or the presidency is not an office, and that the president is not an officer, is bizarre. Yeah. One of the things that was argued or suggestion is that the list of folks in Section 3, senator, representative in Congress, elector of president and vice president, that the suggestion was, well, that list is one that should have included the president if you wanted the president included. The problem is that after that list, it says, or any office, civil or military, under the United States.
Yep.
Now, the presidency clearly is one of those things. Here's part of my point. Part of my issue is senator, representative, elector of president or vice president, elector of president and vice president. Those are all functionally state offices because they're elected by folks in states. Mm-hmm. The president is clearly a federal office holder because the president is the one who is selected by folks in all, or at least by electors from all different states. Mm-hmm. But he's clearly also an officer, an officer of the United States, either civil or military of the United States. As commander in chief, etc., he's clearly covered. And to say that he's not, it's just a very strange thing. And as Sue noted, there was a prior draft that had the president listed, but that draft was not one that was ever considered by Congress. And the guy who wrote that draft later said in the congressional record, "Oh yeah, there's no reason to put president in there because he's covered under the all officers." So that has always struck me as being a bit of a red herring. The problem that one has run into is that the Colorado trial court seemed to buy the argument, and that's what gave it a little bit of life.
Well, and what's also interesting, and Trump just seems to be the exception to every rule in American history, he's the only person ever elected president who had not previously taken the oath prescribed in the 14th Amendment. Sure. Everybody else had served somewhere in this country as a federal official. And then along comes this guy.
Right. So
when Sotomayor says insulating this court and Trump from future controversy, you just go, oh my.
Right, and I'll tell you one more little hidden piece is the notion that the president takes a different oath, even though the president's oath is still one, I would argue that requires that the president support and defend the Constitution. What do you do with the vice president? The vice president doesn't take the president's oath. The vice president takes the other standard oath. So
Other
it would be
standard
odd to
oath,
say,
yeah.
right. So the suggestion is, oh, so the vice president is covered, but the president's not covered. That's just nuts. I mean, come on.
I think, Hank, you alluded to the congressional record because somebody actually in the debates over this, when they had the original phrasing and then they came back with what we currently have, and I think someone asked the question about this, and I think the person that said, well, look what it says, all other officers, and so he's covered. And the guy that raised the objection, I forget the senator's name, said, oh, gotcha, never mind.
Right.
So he was good.
Right.
Though I don't know that, I mean, I know sometimes the court uses history and sometimes it doesn't. Sometimes it cherry picks history and sometimes it doesn't. And
yeah,
so,
well, I'll tell you, there's a real irony when Justice Jackson asked the oral argument folks, well, what do you think about that particular argument? Interesting enough, Trump's attorney said, well, that's kind of law office history. And I thought, oh my, that is really interesting, because what he's essentially saying is, yeah, that argument's just made up, and I'm not going to stand behind it as a reason to apply section 3 in that particular way. So I thought it was fascinating that he said that at that time.
So Chris, I'd like to get one more question in
Sure,
before we
yes.
hit our 60-minute mark. Selena Yan asks, I have a question regarding the action by the states. Do you think the states which did originally remove President Trump from the ballots were furthering the ideals of laboratories of democracy? And does the Supreme Court decision infringe on their power to oversee election administration?
Yeah, it's a good question. I would not necessarily go with the laboratories of democracy notion. Here's the reason why is laboratories of democracy suggest that we can apply particular rules in different ways depending on how the state feels. I think here all you had was a state saying, we're just trying to apply the language of the 14th Amendment in a way that we normally do. So I'm with you in terms of the interest of the notion of states making determinations on their own, but I wouldn't call it laboratories of democracy. But I think it's a great question. And yeah, they do trench on the state's ability to run their elections, at least in some ways. Question is how much they will trench on it in the future.
Yeah, and it requires looking at each state's electoral code or election code. And I'm sure states are going to go back and rethink a number of the provisions in light of this opinion.
Thank you so much. And that was beautifully brought together here at the conclusion. So thank you again for everyone viewing this evening. Thank you very much to our moderator, Chris Cavanaugh, and to our amazing panelists, Hank Chambers and Sue Leeson. Thanks so much to all of you, and we hope to see you again at our next iteration of 60 Minute Civics. Thank you.